make sure we're on the record, and then we'll get started. Do you know?
That's the record right there. We're on.
We're on. Okay. Is it the green light?
Yeah. Well,
okay.
And the cameras are on, so we're good.
Great. Make sure my tie's straight. I noticed in a previous recording it was all goofy, but I'll go ahead and call this session of the City of Issaquah Hearing Examiner to order. For the record, today is May 20th, 2019 at 10 a.m. We have one item on the agenda today. This is number BLD 18-00387, an appeal of a denial of a building permit related to tenant improvements at 710 Fifth Avenue Northwest here in the City of Issaquah. My name is Andrew Reeves. I'm a hearing examiner with Sound Law Center, who the city has selected to hold certain land use application and appeal hearings like the one we are here for this morning. And today it will be my role to sort of observe the evidence submitted in the form of exhibits and testimony to determine whether the appellant has met their burden of showing that an error occurred in denying this building permit. We are represented by counsel on both sides. Because of that, I'm going to keep my opening remarks very brief. And in advance of starting the recording today, we just very briefly discussed sort of how these hearings go. And per the pre-hearing order, we'll first hear from the appellant and their witnesses. Then we'll turn it to the city and any witnesses they may wish to present. And then if the attorneys would like, we'll give them an opportunity for closing arguments at the end. Did the attorneys have any interest in opening remarks? I know that wasn't really covered in my pre-hearing order.
Yes, I do.
Okay. So I will allow that. Mr. Haney, any interest in that, or do you want to wait for your side?
We'll wait.
We'll wait. Okay. So we'll go ahead and start with opening remarks from Mr. Pasig. And again, I noted in advance that with witnesses, I don't need a ton of foundation laid. I know that everyone that has been called or it's intended to be called is professional, and the questions asked can be a little more open-ended. I will obtain objections if they are brought up by the attorneys, but we are going to do away with some of the formality of the court. So with that, Mr. Essig, thank you for being here. If you can just sort of introduce yourself for the record, and then feel free to start in with your opening remarks.
Yes, my name is Michael Essig from the O'Brien Law Firm. I am here as legal counsel representing the appellant.
Great, thank you for being here.
As you stated, we are here under an appeal for the City of Issaquah's denial of a building permit for tenant improvements, and I want to emphasize tenant improvements, within an existing, already permitted, already segregated tenant spaces. The city initially denied the permit for what we have called tenant B space, based upon factual and code inaccuracies or interpretations. And as I reviewed this independently before, when my client, sent me all the information, I have to admit that I was truly surprised by what I observed and what I expected based upon reading their letters. Their letters, responses, April 2nd and April 19th, or 18th, paint a picture very different than the facts. The city has seemingly gone out of their way to ignore the facts and take different pieces of different parts of the code, the IBC, the IEBC, to support their initial decision, which was based on inaccuracies, factual and code inaccuracies. I also want to state that the building owner attempted to get from the city contact information to what appears to me a integral witness, which is Mr., I'm going to pronounce it, Reithner. I don't know how to properly pronounce it, who was the person who approved the plans previously, but we were denied his information. The city is claiming that the partition walls, which is what this permit is about, is made less safe. So, let's be crystal clear. My client, applied for permits for these 3 partition walls. however many you want to call it, and nothing more. And I'll repeat, the city claims that those partition walls make this building, which has 3 prior approved permits for this space, as being less safe. The petitioner will provide evidence on the history of the building, the history of the permits on this floor, why the existing space is exactly the same with regards to safety as it was in 2012, 2013, and a 2018 permit for Space A. And therefore, why the petitioner's permits must be granted.
Great, thank you. First off, before you call your witnesses, I wanted to point out I did hand sort of witness and document lists with what my office believed to be everything submitted in advance to both sides. Do those look accurate to both parties? And if so, can we go ahead and have the documents admitted into the record without objection, and if there are no objections? That'd be the document I handed
Again, we object
to one of the witnesses, correct?
No, to one of the
To
documents.
one of the documents, okay. So we'll get into that in 1 second. What is, Mr. Issaquah, then which document did you have an objection to?
That would be C. Let me not open my mouth here. I want to make sure it's C3.
And what is the grounds of the objection?
A variety. First of all, it's hearsay. There was no documentation as who was spoken with. We clearly had no opportunity to call the same person, whoever they are. No knowledge on the facts that were presented this person, because they're basically trying to get this person admitted as an expert, that their decision is accurate, which we, of course, completely deny. If they wanted to bring in a separate code expert, they could have, should have, or even if they wanted telephone testimony, I may have permitted it, but no opportunity to find out what laid the foundation for this letter that was drafted by I don't even know who.
Okay. Mr. Haney, any response?
Yes, first with respect to hearsay, this document, my understanding is that the hearing examiner's rules of procedure do not require that parties proceed according to the strict rules of evidence, that you can take this into account and take it for the weight that it will be given. Mr. Hinton will testify that he prepared this document, that this is a record of his conversation with the ICC, who confirmed his interpretation. We're not going to be offering it. I mean, I think you can just give it the weight which it deserves as opposed to excluding it as a matter of evidence.
That's the ruling I am going to make, to the extent that, again, as I pointed out, our rules are not quite as strict. I'm fully aware that it's hearsay. I'm fully aware that from your perspective it would have been much preferable to have been able to talk to the same person, but I believe we will have a witness that their side will be calling that you'll be able to cross-examine in relation to this document. So I'm going to allow it, again, knowing that the sort of weight that will be granted to it is such that it is clearly a hearsay involved.
And clearly it's being offered for the legal, or I keep saying legal, the conclusion on the application of the code.
Right.
And clearly we have no idea what facts were presented
Sure.
to that person.
And I think you'll be able to sort of flesh some of this out when you cross-examine the witness that prepared the document. But I would keep this in mind and feel free to make the argument to me in closing that you think I should give this very little weight. I will note right now that you think I should give it very little weight. But for purposes of admitting exhibits into the record, we tend to be more inclusive. And but I'm putting a star right here that says Mr. Essig notes that in his view I should grant this very little weight because it's hearsay.
And I would respond simply that I think this exhibit goes to the steps that the city took to try to verify its opinion before making a decision. And that Mr. Hinton didn't rely simply on his own review of the code based on his experience. He contacted others to make sure he was not making a mistake. And I think that that is certainly admissible testimony regarding the steps he took to make sure he was not making a mistake in this circumstance. So that's part of the purpose for which it is offered, and I think the weight you can give it is up to the examiner.
Certainly. Thank you, Mr. Haney. Noting that objection, were there objections to any of the other documents that both sides have then submitted into the record? Mr. Haney?
I have no objection.
Okay, so we'll go ahead and deem exhibits. What I have is A1 through A19. Those are the appellant documents as admitted. City documents C1 through C3. I note there was an objection to C3, but I have deemed it admitted, and I have transcribed the arguments both sides have made in relation to why that document should or should not have been admitted into the record. So I'll go ahead and say that, by the way, is there anything else the parties had intended on admitting today as additional exhibits?
Not as exhibits. We may put up some sections of the code.
Sure, and I can always take legal notice of something like that. So, great. So then our documents have been submitted, and I think we can go ahead and dive in with your witnesses then, Mr. Essex.
First witness, Brian Paladar.
Okay.
Do you want him to sit front and center, or?
No, I think this is fine. The mics are everywhere. I will swear you in. But Mr. Paladar, do you swear affirm to tell the truth in any testimony you give here today?
Yes, I do.
Thank you for being here.
Mr. Paladar, you talk about foundation. Please explain your work on this project.
My office was responsible for the design of the overall building shell of the Transnet office building, as it was originally called, dating back to 2012. The example floor plan is, I guess, the upper left-hand board that you have there as a 3-story office building. Our office has been involved the entire time doing all the tenant improvements on the building, and other examples are illustrated on the boards over there. It is also my stamp on the drawings. I'm the licensed architect of record on the project for all phases.
So that was the initial design began in 2011?
Correct, yes. A building
Okay.
permit issued in 12.
Okay, so you were involved in 2011. Were you involved in pre-construction meetings with the city?
I honestly don't remember what the pre-construction meeting would have happened if I was in attendance to that. I did not review that record prior to today.
Okay. And what is the purpose of an architect?
Purpose of the architect is to protect life safety and public welfare. I mean, that's what we're licensed for. So our job is to design a building in accordance with local codes, or I should say applicable codes, because that can include national and other concerns. So our job is to prepare the plans in accordance with the codes so that they can be followed for accuracy and built appropriately.
Okay. And codes can be interpreted differently, is that correct?
Correct.
And as you stated, your job is to design a building, is a fair summary, design a building that meets the code.
Correct.
I'd like to point out Exhibit A11. Let me start by asking, who is Gavin Erickson?
Gavin Erickson was the one of the project designers in my office at the time that this was going on. He was, besides myself, was the principal person involved on the project.
Okay. And Exhibit A11 is an email, a very short email string between Tom Reithner, am I mispronouncing that?
No, that's correct.
Okay. Tom Reithner and Mr. Erickson, correct?
Correct.
And are you familiar with this email?
Yes, I am.
And are you CC'd on this email?
Yes, I am.
The string begins on the second page. And Mr. Erickson is asking questions about the ingress and egress for the code. Could you? And directing it to Mr. Reithner.
Sure.
Can you read the whole thing?
Says, email says, Tom, we are looking at possible tenant plans for the Transnet office building, original permit number BLDs 11-00135. And we're looking at for some egress feedback. I've attached a sketch plan of this floor for reference. Goes on to cite the code section 1015.1. The code section basically allows the entire floor, both divided or undivided, to have to have one exit per space. However, sections 1021 and 1021.1 indicate that all spaces on this floor will need access to 2 exits. Our question is whether or not the attached sketch would meet the intent of these sections without continuing the hall all the way to the southeast stair. Since both of these tenants would have access to 2 exits and the limited occupant load on this floor, could this be an option? Any information that you provide would be helpful. Thanks.
And that, can you please read Mr. Reithner's response?
Mr. Reithner's response was dated February 13th, that was my final one. November 25th. Says, yes, I think that meets the intent of the code. Since each tenant has access to 2 exits through their own space, it is similar to having a common lobby.
Okay. So this, do we have to call the exhibits, like numbers?
Do you know what, I know I have the exhibits, but
Yes,
do you know
they
what
are-
that references?
Yes, they are all pieces of not that one, hold on. That is A9, page 25.
Sorry, is 25 like a Bates number?
No, it's technically it's A203.
A213, A213?
203.
And A9, I don't know why I don't have that.
I don't have it either.
I wrote in A9, page 25, A2.03.
I have A213. I go from G0.00
That's
to
just the front.
A213. I know there were several documents that had.
Did I miswrite which one?
Or TI, that's the lower level board.
This one.
Oh, yeah, that's the original. That's correct.
Is that A9?
Yeah, this is the only print that was.
Did I print the wrong page?
No, sorry. I think you printed the wrong page. That is exhibit 9 though. It's fine. You need your binder. Yeah, but that's it though. That's all the registers.
Okay. I didn't want to submit every page of all of the plans because it would have been hundreds and hundreds of pages. So I cut and picked. That I wrote down as A-9, page 25, being A203, as it states right there.
So you had intended on submitting that, but accidentally submit 213, is that?
That must have been what I did.
I mean, it shows the same sort of building overlay.
This is
This is
reflected
a ceiling plan, I mean, but
and it was supposed to be
the floor
the
plan.
floor
right?
plan.
Mr. Haney, any objection to them submitting A203, the one they had intended on submitting?
I can have just a moment.
Sure. One sec there.
Sure. No, that's the next one. I started to print them out, and I went, oh my God.
Similar. We don't object.
Okay. So make sure we get a PDF version of this for both myself and the city.
Yeah, no problem.
And we'll make that, we'll just add that in as part of A9. Is 213 going to be involved today at all? Okay, so we'll just essentially replace 213 with 203 with the city's blessing. So if you
Okay.
want to keep going, that's great.
Okay, thank you. So, the only reason for offering this up is, well, basically two reasons, Mr. Paladar.
Sir.
This was the initial plans for the building, correct?
Yes, for floor 3.
And this, admittedly, these original plans show no tenant improvements within the space.
Correct. The tenants had not been solicited yet, so there was no reason to document the space further.
Okay. And in these plans, it actually shows a door here and a door here, correct?
Correct.
And these plans were approved, correct?
Correct.
Okay. Was Mr. Erickson's email related to the 2012 plans?
No, it was not. It was related to the tenant improvement plans that were soon to be submitted during construction.
In 2013?
The next tenant improvement, yes.
Okay. So this is, better be, in A10, page, I put page 3, but this was me pulling it out. It's A 2.0.
That we do have.
Okay. So, Mr. Paladar, so it was for these plans here?
Correct.
And when these plans were drawn, was this whole space one tenant or two tenants?
It was originally the one space. It was being separated into two separate tenants. I think it was called tenant space A and B. Is that correct?
Tenant A and B?
Yep.
Okay. As a result of Mr. Reithner's comments, what did you do when you designed the space here in 2013 for the TI improvements?
Our objective with the space was to subdivide it into the two tenants as requested by our client and the incoming tenants that were proposing to be there. In order to provide access to the two required exits, we, as part of that coordination with Tom, identified that both of the units could have one exit out into the hallway space that then connects up to the elevator and the stair in the upper left, and that in an additional small corridor essentially would be created on the southeast stair so that each tenant would have joint access to the separate second exit, and while still providing their own security to that stairway, because the stairway was so small we couldn't actually fit in multiple egress doors on that same stair landing. It's also a wood frame building, so we were limited with where we could continue to place additional holes and shear walls and things.
So the change that was made from here to here was only, well, besides the interior partitioning, was that you added a corridor, essentially, I'll use the word adjacent to the second stairwell.
Correct.
And that corridor provided a door for tenant B and a door for tenant A.
Correct. It was really exit-only type of configuration since both tenants were separate.
And consistent with that letter from Mr. Reithner, the problem you're trying to solve was to provide two exits for tenant B, one out this door for the back stairwell, and then access to the northwest stairwell.
Correct.
And the same thing for tenant A, separate exit, access door to the southeast and to the northwest.
Correct.
And consistent with your interpretation of the code and Mr. Reithner's response, that satisfied the code.
Yes.
And those plans were approved.
Correct.
And that space was built.
Yes.
Eventually, those tenants moved out, correct? Or are you aware that the tenants eventually moved out?
Yes, the tenants have changed over since those original applications.
So in 2018, 2018, you redesigned the space for tenant A.
Correct.
Okay, and that is A13.
Okay, A13.
Is it the A 2.0?
Yes, A13, Mr. Haney, A2.0 is, I believe, what we're looking
And from the 2013 build-out, what changed to 2018?
Not much. Basically adding 2 small rooms for use as a massage physical therapy environment, and I think we shifted around 1 or 2 other small walls. Otherwise, the majority of the space remained unchanged. And there was no change to exits either.
So it appears from this that the small wall and this large space was partitioned into 2 offices.
That's correct.
But the egress door for tenant A remained in the same location?
Correct.
And they therefore had egress from the northeast stairwell and the southeast and northwest out the corridor that was designed with the original tenant improvement.
That's correct.
Okay. We then, and those plans were approved, correct?
Correct.
And the space was built. And it's currently occupied exactly, well,
That's my understanding, yes.
it's occupied. We then move on to tenant B space. This is the permit that was denied, correct?
Correct.
You have a
What?
exhibit number there, Mr. Essex?
oh,
I
sure.
think we've changed exhibits again.
Yes, we did. So we're A-1.
Okay, A1. Okay, A1, and it looks like
There you go.
4th or 5th sheet, but A2.0 of A1.
Yes.
Okay, sorry to interrupt. But
No, not a problem. When you don't like foundation, it's a little different.
I know.
What difference is there between the 2013 build-out and the permit that was applied for and denied?
The addition in the central space, there was an addition of, appears to be a hallway wall and 3 partitions that separate and create some offices, but there was no change to exiting.
Again, same thing, which is, it appears from the plans that this large interior space was partitioned up with a few walls,
Right.
but the door to the southeast stairwell remained unchanged,
Correct.
and the doorway to which provided them their second access to the northwest corner remained unchanged.
Correct.
Is that correct? To your knowledge, were all of the approved plans reviewed by a fire marshal?
To my knowledge, all required, well, I should clarify. To my knowledge, all typical city reviews were performed and approved.
Okay.
I can't comment on specific within a jurisdiction what is required or not, but typically fire reviews it, building reviews it, usually ordinance mechanical, or mechanical will include it as well if there's something related on there.
Okay. Was there any disapprovals or denials based upon your history with this denied permit besides the door, the whatever you want to call it, door? There's too many doors.
There were no other permit comments that I recall that materially affected the project. It was all typical plan comments, add notes on the drawings, clarify something for me over here, but there was nothing that was a denial other than that one item.
Okay. I think I'm done asking questions. I'll reserve the right to call them back.
Sure.
Okay.
Mr. Haney, do you have cross-examination with us?
I do have a couple of questions. So if I understand correctly, Mr. Paladar, you were involved in all of these various iterations of plans, correct? And Mr. Jackson, was it?
Gavin Erickson.
Gavin Erickson, I'm sorry. Mr. Erickson was working under you.
Correct.
Let me ask you about exhibit A12, excuse me, let me just make sure. No, A11, which you testified concerning.
This would be the email.
Yes.
Okay.
So you testified regarding Exhibit A11, and you indicated on the second page of that, and then I guess on the first page of that, you had, or Mr. Erickson had an email exchange with Mr. Reithner regarding the building and the exiting.
Yes.
You have to answer audibly for the tape.
Yes,
I'm sorry.
yes, sorry, yes.
Yes. So let me ask you about the second page of that. And this is the email from Mr. Erickson to Mr. Reithner. And it says 1015.1 allows the entire floor, both divided or undivided, to have one exit per space. However, 1021 and 1021.1 indicates that all spaces on this floor will need access to two exits, correct?
Yes.
Again, you have to answer
Yes.
audibly. So, Mr. Paladar, you understood, and Mr. Erickson understood, that the code required every space on this particular floor, which I understand to be the third floor, to need access to two exits. Is that correct?
We understood that every normally intended space, i.e. the tenant spaces and the areas that you primarily use, need access to that.
Does the code make a difference between intended spaces or tenant spaces and other spaces on the floor?
I don't recall the specific sections that would specify that further. We normally would track the space and look at the required exits and discharges from the main spaces as part of our egress plans, and we would make sure that we have corresponding access to exits from even secondary spaces. But we would assume that you have access through individual tenant spaces if that was appropriate.
Well, Mr. Paladar, doesn't this email from Mr. Erickson say that these code sections indicate that all spaces on this floor will need access to two exits? Isn't that what it says?
That appears to be what he says.
And he was working under you. Wasn't it your understanding that all spaces on this floor required access to two specific exits?
He was working under me, but I will also comment that he's not listed as a project architect. I'm the licensed architect, and I'm responsible for ultimately the quality of his work. But I also approved the exhibit that was attached to this that explained clearly to Mr. Reithner what our intended layout was as part of this. And it's not uncommon, I will say, that as in any profession, that younger staff doesn't always use the same language that a very experienced staff member would.
Well, did you or did you not, Mr. Paladar, understand that the code required every space on the third floor to have access to two exits?
I do understand that, and I believe it does.
Okay. Let me put up the 2013 plans, if I may. I believe we said this was part of Exhibit A10, is it?
Yes.
And this would be page A20 from those plans. You recognize this? You testified about this earlier?
Yes, sir, I do.
Okay. So, as I understand it, you said that tenant space A has access to two exits. One would be this stairwell in what I'll call is that the southeast corner?
Correct.
Yes.
And the other one would be access to this stairwell in the northwest corner, is that correct?
Correct.
Okay. And then tenant space B, I believe you said, had access to two exits as well. Is that correct?
Yep.
And one would be these stairs in the southeast corner, correct?
That's correct.
And would that also be to these stairs in the northwest corner?
That's correct.
What about the other space here that I believe looks to be restrooms and some other space which is outside of both the tenant spaces? Where are the exits for that?
It would be through the other tenant spaces, because it would be those tenants in that particular level using
Well,
the building at that time.
these businesses might have clients, would they not?
Yes, potentially,
And do those clients have access to all of those spaces?
if they were there during normal business hours.
Well, if a client was out here and had access, would they have access through here? Through this tenant space to get to this? To this stairwell?
Not at the time if they showed up at a non-business hour.
So these spaces, I guess, what I would call in the north quadrant or north half of this area, these non-tenant spaces, those have access to this stairwell in the northwest corner, correct?
Yes.
But they don't always have access to this stairwell in the southeast corner, is that correct?
Literally, no.
And you understood that the code required access for all spaces on that third floor to two separate exits, is that correct?
I understood that it was for access to the required exits for the proposed uses.
Now, Mr. Reithner on the first page of this email says, yes, I think that meets the intent of the code since each tenant has access to two exits through their own space. That's correct. Each tenant does have access through its own space, correct?
Correct.
So what Mr. Reithner is referring to there as meeting the intent of the code is that each tenant has access to its own space.
That's my understanding.
Does he specifically address in that email the area with the restrooms and the common areas?
He does not. However, I would add that it is commonplace for at least my office to have these types of advanced discussions with code officials to try and make sure that what we're going to resubmit actually meets the intent of the code and that we're trying to address things, and that we have typically relied on feedback we get from jurisdictional staff that if we give them a plan and say this is exactly what we're proposing to do, and the jurisdictional staff says this appears to look good to us, we should be entitled to rely on that. And we did.
Well, I understand that's your impression. Now, Mr. Reithner obviously approved the accesses for each of the two tenant spaces. That's your understanding.
Yes.
But you don't understand this email to specifically approve the access to that non-tenant space, correct?
It does not state that in the email, no.
But overall, you did receive a permit for this work, or your client did receive a permit for this
correct.
work. Okay. Now, let me ask you to turn to Exhibit A12, which you have. Well, strike that. I'm not going to ask you questions about that since you didn't testify regarding that in your direct. So let me ask you about the 2018 plans, if I could. So we've got the partitioning that is going on in tenant space B, correct?
Yes.
Tenant space B, if this is approved, will have access to 2 exits, correct?
Yes.
It will have access to this stairwell in the southeast corner and this stairwell in the southwest corner, correct?
Yes, northwest.
And tenant space A will continue to have access to 2 exits, the stairwell in the northwest corner and the stairwell in the southeast corner, correct?
Yes.
And again, tenant space, or excuse me, this non-tenant space area, the restrooms and this non-occupied tenant space, it will only have access to 1 stairwell, correct? The stairwell in the northwest corner, when this door is locked.
I can't comment on the restriction on that, because if tenant space A is normally occupied, then occupants on that level would presumably be with tenant space A and therefore have access to both exits.
Do you know, Mr. Paladar, does the building code allow you to count access through another tenant's space as the access for exiting purposes?
There is specifically a section regarding that. We did not use it for purposes of these applications.
I have no further questions for this witness.
Thank you. I actually do or did you want to redirect before I ask my questions?
I'll let you do it. One thing I guess I should have laid the foundation is as Counselor said, that's common area. Everything he's referring to is a common area space utilized by both tenants.
Well, so one of my questions was, Mr. Paladar, that exhibit A11 we were looking at, I was curious what your understanding of the word common lobby was in Mr. Reitner's comment. Is that the space we're talking about?
Essentially, yes, the hallway. So in many environments, such as with similar occupancies, such as either office buildings or perhaps a retail environment, where you would have a series of spaces that all might have a direct exit to the outside as their second exit, just out the back of the space, typical convenience store kind of approach. But all of these spaces might share a single common entry point. That's allowed to be their separate egress point. And so it was a similar concept in this case because we had the access to the southeast stairway.
And also related to that same exhibit, Mr. Paladar, you had referenced in your responses to Mr. Haney that you had attached plans to this email set. Are these in are these the plans that were attached? Sorry, I did not phrase that very eloquently, but these 2013 TI plans, A20, is that what your understanding is?
That's correct. That's
okay, so this sort of Exhibit A11 is referencing that particular plan. And then my final question is, didn't that area, if we call it the lobby or the common area between the 2 tenants, was that built out back in 2012 or 2013?
That was in the original permit set, yes. Correct.
And has there been any changes to that area since then?
Not to my knowledge, other than what would have been declared. I think there's a minor adjustment as part of the, okay, so this is the original building plan. I guess the only difference, I think, was the original building plan had a larger lunchroom area, and the first permit application to create both tenant spaces actually took a chunk out of that lunchroom area in this part. That's the only difference. And that was permitted work and built per that plan.
So thank you. Those were the clarifying questions, so I understood. Thank you. Did you have further redirects?
Yeah, I had one question. Mr. Paladar, to your knowledge, is the word space defined in the code?
I don't recall offhand.
Which code? Sorry.
IBC definition of it.
The IEBC or the IPC?
I don't recall offhand if that's a specifically defined term.
And I guess I want to emphasize, these 2013 TI plans were permitted.
Correct.
And the ingress and egress access for the people who used this space whether they were in the common areas or in their own separate tenant space, all had access via two means of egress.
That's correct.
Sorry, one more question, so I don't misunderstand. I believe at one point you had said there were tenant A improvements sometime in 2018 that were approved. Is that accurate?
That's accurate.
Okay. And that is an exhibit, I just don't remember which one, and I know it's one of your big boards. Okay.
Am I allowed to semi-testify or clarify? Which is?
You're not allowed to testify, but you can clarify.
So here was the 2013.
Sure.
And then 2018, it's the
It's
same
those two,
space.
sure.
The only thing that happened, I'll just refresh your memory, was this.
Yeah.
But their door didn't change, their door didn't change,
Yeah, I think I understand. Great, thank you.
and tenant B was occupied.
Was that it then from this witness?
Yes, I believe so. Did you want to recross?
Did you have anything further on there?
If I could, with respect to tenant space B, are you aware of when that space was first occupied?
It was occupied as, I would assume shortly after final inspections on the 2013 permit that created the space in the first place.
Was that space ever built out in any fashion?
Yes, it was fully built, fully inspected.
And do we have plans in this plan set that shows those?
Yeah, the copy of the approved set was included as part of the exhibits, and I believe, I don't remember which exhibit, apologies. I believe the inspection report may have also been included, documenting that it had been.
And do you know if any tenants that were in there actually obtained business licenses or other?
As the architect, I typically don't follow up on business licenses unless it's a jurisdictional requirement that I submit them with the building permit application.
Okay. No further recross. Sorry.
The building owner is here and can answer those questions.
Okay, which he was on your list, wasn't
Yes, he was.
Okay. So then I think we are done with Mr. Paladar, is that right?
Okay, yes.
Thank you. Your next witness?
Mr. Andy Higgins?
Is that you? Thank you for being here. Do you swear affirm to tell the truth in the testimony you give here today?
I do, sir.
Mr. Higgins, can you give us a little bit of your background, your job title, your expertise?
I am an independent consultant hired to be an expert witness. I'm a master code professional at the International Code Council. I started as a building plans examiner and permit specialist in the late 90s out of construction management school at the University of Washington. I've worked in multiple jurisdictions locally, Seattle, Kirkland, Sammamish. I've done consulting plan review work for multiple jurisdictions, Issaquah included, Mercer Island, and others. I was a building official in the city of Sammamish in 2007, and I currently am the Director of Engineering Services in the city of Seattle.
Exhibits A5, A6, and A8. So that's A5, 6, and 8. 5, 6, and 8. Did you draft each of those documents?
I did.
Okay. A5 was dated 3/5/2019.
Yes, it is.
A6 is 3/6/2019.
Yes.
And then A8 is 4/5/2019.
Correct.
And that document was written in response to the second denial of the permit.
Yes.
Okay, so let's start with A5. Specifically, the summary on the last page. Okay, I know we can all read.
And just so you're aware, I've read everything in advance of the hearing, so
Okay.
I don't know if we need a verbatim reading into the record. I certainly don't know if it's going to help anything.
Okay. Is it fair to say that that summary is your conclusions based on the analysis in the previous pages?
Yes, it is.
Okay. Let's start then on page, I think it's 2, where the actual analysis begins. make that 3.
Sorry, and we're on A5 right now, is that accurate?
Correct.
Okay, great.
3/4. Actual analysis kind of starts on page 4. One of your opening comments is regarding the word alteration.
Correct.
What does this mean with regards to, or the significance of the word alteration in the code?
So the significance of that word would determine which code applied to this work. If this work is alterations to an existing building, then the code that would apply to the work would begin in the International Existing Building Code as adopted in Washington State. And the definition of that under the scoping provisions indicates that.
Okay, and specifically, because the issue here before us today has to do with the door from tenant space B that the city is objecting to. What does the code related to this door, what does it mean with regards to having to satisfy the code, or which code does it need to satisfy based upon your expertise?
Right. So the International Existing Building Code specifies in section 101.4 in compliance that alterations shall be such that the existing building or structure is no less complying with the provisions of the International Building Code than the existing building or structure was prior to the alteration. So the scope of the work under this permit application for those interior non-bearing tenant partition walls would be the limited scope of what would be reviewed under this application, in my professional opinion, and that any other existing building elements that had been previously approved would be outside the scope of what would be reviewed.
So it's your testimony, therefore, that the only thing the city is allowed to review is these partition walls?
That would be where we would start, yes, correct.
Because the fact exists that this door was already permitted.
Correct. And part of my analysis was to go look at the permit history and to validate that, verify that that was in fact correct.
You made a reference to something that the city consistently makes reference to about I call it the magic words, less safe.
Correct.
What is the significance of those terms when it comes to the code?
Right, so the alterations being proposed can't make the building less safe. So for example, if the applicant had been taking out or removing that southeast corridor space and trying to modify the walls related to that and make it such that the other tenant space needed to exit through this tenant space, then I believe that would have been making the building less safe and therefore would not have been allowed by the code.
So what you're saying is, if for some reason they closed this off somehow, so that tenant B lost their access to this stairwell,
Right.
except through A, or vice versa,
Right.
you closed off A's so that A had to, they essentially had to and you put a door in the middle or something, and they had to go through this space, tenant B, that would be less safe.
Correct, the code clearly prohibits that.
Okay. Based on your professional opinion, going back to the 23 plans which have a notation that the door must remain unlocked during business hours, did it comply with the code?
I believe it did, and I believe that based on the interpretation of the building official at the time that approved that set of plans, I believe that the interpretation that that building official had was that if the two doors to the other tenant space were locked, they could consider the rest of the spaces, the common spaces, and that tenant space, is it A on the right? Is that?
This is B.
Sorry, tenant space B. All of the common spaces would still be able to access the exits through that tenant space and thus would maintain access to two exits, not just the northwest corner, but also the southwest corner during normal occupied hours.
The city has made today, here as essentially through cross-exam and testimony, keeps referring to the common area spaces. The bathroom, I believe this is a storage room, as not having double accesses, two accesses. Is that a fair characterization of, I don't want to miss
Access to two exits.
access to two exits?
Right.
You testified that if this door was locked, this space is still code compliant.
Correct.
And is that because, as Mr. Reichner referred to it, common lobby and stuff, a common lobby in his email, is that because the only people who will be using this will be the tenants and their, I'll use the word invitee to the space?
I believe he used the word similar to a common lobby, and yes, because those normally occupied spaces in the restrooms or in the lunchroom would be only occupied during the time when that adjacent tenant space would also be occupied, and thus approved the door to remain unlocked during normal business hours. I may have phrased it differently. I would have potentially said during normal occupied hours, just because normal business hours may or may not be the same. But I believe that his interpretation was that during normal business hours, those would be the occupants using the space and therefore would remain having access to two exits through that space that was being occupied and utilized.
Does the code require 24/7, I'm going to say two egress points, 24/7 to every single solitary space on the floor?
No, it does not. I believe that's the determination in the code why the different occupancies are defined and why they have different requirements. B occupancies in the commentary are it's very specific that it calls out that the risk to life safety in business occupancies are relatively low. Exposure to the potential effects of fire is limited because business type facilities most often have low fuel loads, are normally occupied only during the daytime, and with some exceptions are usually occupied for set numbers of hours. The occupants, because of the nature of the use, are typically alert, ambulatory, conscious, aware of their surroundings, and generally familiar with the building's features, particularly the means of egress. And historically, this occupancy has one of the better fire safety records for the protection of life and property. So therefore, it has different requirements than, say, a residential occupancy where people might be asleep at night, and therefore would have different requirements like required openable windows and egress openings, sprinklering, things like that, as well as things where you might have jails or other occupancies that would have higher fire life safety requirements than a B occupancy would have.
Right, so a public space like a library, where one only knows where to exit based upon a sign attached to the ceiling or something, would have a different requirement for egress, possibly, than an office building.
Possibly, and also depending on the occupant load. The library might have a much larger occupant load than the B office building. It may or may not be the same occupancy type, but the character of that occupancy may trigger other life safety requirements.
And that's really, in your professional opinion, one of the essentially elemental differences here is that the common area is used by occupants and invitees, as in people who are coming to use these businesses.
Correct.
And when the businesses are open, it is a requirement that their door is unlocked.
Correct.
And it is required to be unlocked, and including tenant B says that it must remain unlocked, and there must be a sign that says it remains unlocked, correct?
Correct.
And it is that way so that they have the two egress points required by the code.
Correct. This is a very common code problem, frankly. In the high-rise building that I work in downtown Seattle, when you step off the elevator, the door to the applicant services center is locked. The door, there's a elevator lobby and a corridor or hallway down to the men's restroom, similar to this situation, and then there's a tenant door that's also locked. When you're in that space and you come before business hours and you get off the elevator, you're in a confined locked space with zero access to exits. But the common solution to that is to have a situation where there's a interconnected lock on one or both of those doors to the fire alarm system. that would disengage that lock in the instance of a fire, and many building officials would use that as their approved code alternate. In fact, it's so commonplace that in the city of Seattle, they've actually added that to their code as an approved code alternate to provide an interlocked locking mechanism in that situation, so that if there were a fire in the building, it would disengage that lock and would provide access to exits.
And that was the proposed solution that was denied.
That was the proposed solution to the initial correction from the city.
Right.
The prior solution that Tom Reidner approved was to allow the lock on the door with a sign that said to remain open during normal business hours, similar to the provision in the code for main door exits. I concur that this is not a main door, but the interpretation that he used and approved was the similar code provision to allow a tenant space to have security or a right to security of their tenant space, but also allow any occupants of that building to have their right to a free path of travel to the exit in a safe building. So he could have required the interlocking mechanism. That was the proposed solution to this correction item, even though I feel like it wasn't necessary to go that far because there was already an approved method that was existing for this building, and that the proposed scope of the alterations don't at all in any way affect that existing permitted and approved door.
And that was your analysis, that the proposal, if I'm correct, the proposed solution should have been unnecessary because the plans as submitted, and there was a not less safe situation, should have been approved.
I believe that the scope of the proposed permit under the International Existing Building Code should have been reviewed to those proposed alterations only, and any other existing elements that were not being made less safe should have been left alone and not addressed.
So if they had done something in this tenant space other than, as we said, partitioning and cut off a wall, that would have been less safe, and therefore that would have given rise for a permit denial.
Sure, if they had expanded the space or had changed the exit paths or done something to actually affect exiting, I would have said yes.
Okay. Let me move on to Exhibit A8. You state on page 3 I'll give him a chance. You state on page 3 about the choice of code. Please explain the significance of the appellant's ability to choose the methodology for code compliance.
Sure. So in the corrections letter issued by the city, I believe that it said that the applicant shall use the work area method. And the code, in fact, says that if you look at the 2015 International Existing Building Code, Section 301, it says that the alteration, change of occupancy, addition, or relocation of all existing building structures shall comply with one of the methods listed in Sections 101.1.1 through 101.1.3 as selected by the applicant, and that these sections include, among others, a prescriptive method and the work area method. But that it's the choice of the applicant, not the city official.
Okay. Is there any significance to your final conclusion as to which methodology you choose?
It doesn't really matter because at the end of the day, it basically the code says that the alterations shall comply with the requirements of the existing building code and be no less conforming than the existing building or structure was prior to the alteration. I believe that the letter from the city indicated that it shall comply with the requirements of the International Building Code for new construction, which I don't believe is accurate.
And again, because no exterior, or I'm going to say use the wall separating the tenants or the existing door are changed. Therefore, what is appropriate, because it's only interior spaces, essentially the appellant gets to choose.
Correct. And I misstated that prior statement slightly, but that the letter said that the alterations must comply with the requirements in place at the time of original construction, not at the time of the application for this permit. So I apologize for that. The distinction is that the alterations must comply with the code in effect at the time of this alteration, and any other prior existing conditions shall be allowed to remain.
And we go back once again to the concept of less safe.
Right.
Is that correct?
Correct.
As long as this space, as requested for in the permit, is not any less safe than it was built, it must be allowed.
Correct.
And therefore, the permit should have been granted.
Correct.
At the bottom of page 3, you point out the city's inaccuracy or mischaracterization of the code. What is that mischaracterization?
Yeah, I partly alluded to that in the prior testimony, but basically that the city inaccurately states that these two sections referencing the work area method, your permit can be approved only if the existing requirements that apply to the structure at the time of original construction continue to be met, and if the alterations to the building do not render it less safe than its existing condition. I believe that was the mischaracterization of the code, and it actually states that the alterations proposed shall be such that the building is no less conforming than the building as it exists prior to the alteration, not at the time of original construction.
And is the building as requested in the permits the same as it was before?
Yes.
And again, the denial was for ingress and egress, and the ingress and the egress is identical.
Correct.
On page 4, you state that the city determined that the requested partition walls create a less safe space. In your professional opinion, is there any way that you can state that the proposed improvements are less safe?
In my
understand my
professional,
question?
yeah, in my professional opinion, I do not believe that the proposed improvements are any less safe.
And that's because they're identical.
The exit system is identical.
Yeah, the exit system, the 2-point egress is the same. On page 5, you state that the city is wrong. How are they wrong factually or legally? I use legally as it relates to their interpretation of the code.
So there was a statement in the letter that acknowledged that the lock in the door in question was allowed in 2013 and approved by building official Tom Reidner, as shown on those approved plans for the tenant space, BLD 00433. The part of the statement that suggested that there is no indication that this was done while the two tenant spaces were independently and legally occupied was the part that I felt was wrong.
And it's wrong because it actually was occupied by two, correct?
It absolutely-
2013 plan
it
had
absolutely-
two tenants.
It absolutely is indicated that way on that approved plan set, yes. Which was also not only issued, but the final inspection was signed off, which would indicate to me that the tenant space was built out that way and authorized for occupancy.
On that same page, you make a statement concurring with the city at the very bottom, your very last comments. Can you please address your concurrence with the city?
Sure. The city of Issaquah's letter concluded with a quote that said, while the stated purpose of the IEBC is to allow existing buildings to continue without change, both the text of IEBC 10142 and Icc Commentary to that section make it clear that only buildings or portions thereof that were legally occupied are covered. And I agreed with that statement because I believe that the door in question and the entire tenant space layout that exists at the time of this application was legal and was fully permitted by the city beforehand, I think appropriately. And this tenant space, or this permits application, the scope of this application was merely for a couple of non-bearing interior partitions within an existing legally established tenant space. which
And
should be allowed to continue.
that statement from the city implies, and therefore their conclusion was that there wasn't two tenants.
Their conclusion was that there was not two tenants, but I'm not sure how they could have come to that conclusion. I think at one point I saw in a letter that said they had no record of it being occupied as two tenant spaces, but I think this permit history clearly demonstrates that it was.
Thank you.
Any cross, Mr. Haney?
Yes, Mr. Higgins, let me first start with Exhibit A5, I believe, and ask you to turn to page 3 of that exhibit. There is a section of the WAC, the Washington Administrative Code, which is listed in that on that page, and it addresses section 101.4.2 of the building code. Do you see that?
Yes.
That section, if I read it correctly, says that these buildings are required to be permitted to continue without change, the part you've underlined. And then it says, except as is specifically covered in this code, the International Fire Code, or as deemed necessary by the code official to mitigate an unsafe building. You see that?
Correct, yes.
You would acknowledge then that the code official does have authority under certain circumstances to require changes to a building to mitigate an unsafe condition.
Yes, I would agree with that. And it goes on to say that for purposes of this section, an unsafe building is not to be construed as mere lack of compliance with the current code. So
Understood,
vesting to
but
the
certain provisions of the code relate to safety and are there for safety purposes, correct?
I think the whole intent of the code is to relate to safety in one way or another, yes.
Right, but for example, exiting is a very important
Absolutely.
part of the building code for purposes of safety, correct?
Absolutely.
So if the building official determined that the exiting in a particular building was unsafe, you would acknowledge that if that was the code official's determination, that the code official would have authority under this provision to require a change.
Yes, I would.
Let me ask about the 2013 plan, again, if I could. Again, it is up here as page A20. Again, I understand that there are 2 exits from tenant space B, 2 exits from tenant space A. And then, if I understood your testimony correctly, there are 2 exits from this area that is neither tenant space A or tenant space B because they could go through the other tenant spaces. Is that correct?
Yes, that's true.
And
It
you
is
meant-
common tenant space, so I would say that it's actually a part of both tenant spaces, not its independent space. If tenant space B were to be totally locked and secured, and tenant space A was open during normal business hours, then that whole area would be considered, in my interpretation, my professional opinion, to be part of one tenant space. Therefore, would not be exiting through a separate tenant space, but would be merely exiting through a portion of its own tenant space during normal business hours while occupied, and vice versa.
Well, that may be true for those people who are tenants. I understand. That would be true for those people who are tenants. Correct?
Tenants or occupants of, or patrons of those tenant spaces.
During normal business hours.
Correct. During normally occupied hours.
What about cleaning crews and other folks who are in the building after normal business hours?
Right? In theory, they would have keys to those doors and would access those doors through their keys and would leave them unlocked while they're cleaning as well.
In theory. But if one of the cleaning crew members was outside in this space and these doors were locked, and they didn't have keys to get in, that would mean that they did not have access to 2 exits. Is that correct?
That would be true, but it would be very hard for me to believe that that would be the case.
So your testimony is that this locking door was permitted under the 2010 code under which this, or under the code in which applied to this tenant improvements in 2013.
My testimony is, yes, it was approved by the prior building official, and it was very clear through the email history that that was an approved interpretation that met the code.
I understand that your testimony is that it was approved. Is it your testimony that it was fully compliant with the code that was in effect at the time?
I believe it was when the building official approved it as an authorized code alternate.
And is there a specific document that you're pointing to other than the sign off on the plans that says that the building official approved as an official code alternate?
I believe it was the email that was referenced earlier that had the attachment with the exact same response to propose this door, and that the building official said, yes, in fact, that it did meet the intent of the code. And 2 weeks later, I believe this permit was issued with that condition in place.
Well, now the email that Mr. Paladar testified to made no mention of this space, this common area space.
I believe the attachment showed all of that floor plan.
The attachment showed it, but there was no specific mention that I'm approving this under the alternate code provision, and I'm approving specifically that exiting from that space, correct?
No official code alternate, but the building official did say in his email that he believed that it met the intent of the code. So that is an interpretation that he, I believe, made.
Now, if a patron of the of either of the business happened to be, let's say that tenant space A has gone home, there's locked up, and attorneys, we know attorneys work fairly late sometimes. If a tenant, or excuse me, if a patron left this facility and this door was locked because the end of the day, these people locked it.
Sorry, which door, Mr.? I can't
Sorry,
see.
the locking door.
Okay, so
The locking door, the only locking door.
isn't A locking as well?
Yes.
So, but you're saying, what if both
So,
doors are locked?
what if both doors are locked after a patron leaves here and then both doors are locked? Do they have access to 2 exits?
What are they leaving for? I mean,
Let's say that a patron came out here and went to use the restroom on their way out of the
Right.
building, and these doors then locked. Would they have exits? Access to the exits?
If they were self-locking, is that what you're asking? Or
It doesn't matter
I mean,
whether people lock them or they're self-locking.
normally occupied hours would have been the term that I would have used for that exact reason, but the idea that someone would walk out there and then be stuck in that space without being able to get back in, I guess if it was self-locking, that could happen if you forgot your keys, but I don't see.
I'm talking about
If you're in a
patrons
tenant
and
space.
clients. If clients were at the end of the day coming out of the attorney's office here and they stopped to use the restroom, the attorney's at the end of the day locks the facility because they're done for the day, this facility's already locked, does that client have access to 2 exits?
Not at that particular time, no.
Now, you mentioned the signage that is on the door about being unlocked during normal business hours. Is there anything in the code that allows specifically that type of signage on an interior locked door?
Not specifically on an interior locked door, on a main door.
Yes, and it does allow on a main door. And
Correct.
doesn't the code define a main door as a door which provides access to the exterior of the building?
It does.
So the code allows this type of signage and locking door as a main door, but it doesn't specifically provide for a locking interior door with this kind of signage.
It does not. You're correct. That was, I believe, the interpretation made by the then building official.
Is there something specific where the building official says, well, I'm making this interpretation that this is like a main door? Is there any document in the record that says that?
I believe that email is what suggested the exact same, that he believed that it was the intent of the code to allow that as they proposed. I believe the architect proposed that as the solution, and the building official at the time referenced that as meeting the intent of the code.
But as far as you're aware, the code does not specifically authorize that.
No.
So if the building official was interpreting the code, he was interpreting the code to say something that is not specifically allowed or addressed.
I believe he was interpreting it to deal with the common problem of tenant security and occupant safety. And I believe that many building officials, like the City of Seattle, would utilize the interlocked locking mechanism as the solution rather than this as the solution. But this was the solution that Mr. Reidler approved.
In fact, this solution in the code is limited to a main door. Isn't that correct?
Specifically limited to a main door, but I believe that the building official has the authorization to make interpretations of code, and if something meets or meets an equivalency, they're allowed to approve that as a solution.
So your testimony is that even though the code says that this particular solution is only to be allowed on a main door, that the building official has authority to interpret the code as saying something different?
I don't believe it says it's only allowed at the main door. It says I believe it says that it's allowed at the main door, but it doesn't specifically prohibit that to be used in this scenario either.
Well, doesn't the code say that are you familiar with the Icc commentary to the code?
Absolutely.
Okay. And I'll ask you to turn to City's exhibit, or excuse me, Exhibit A7, which is, this is an appellant's exhibit. On page 3, there is a quote from the Icc commentary to the code relating to locks and latches on doors. Do you have, it's in italics about halfway down. Do you see that?
Sorry.
Page 3, Exhibit A7.
This is a letter from the City of Issaquah to the owner
Yes,
quoting this section
yes.
of the commentary.
It's
Is it here?
page 1, 2, 3, top of 4. No, wrong one.
It's in the middle of
It's
page 3.
C2.
It's page
I see
3
what you're saying.
of the document that's labeled Exhibit A7.
Oh, I have it here.
Okay. Yes, I see.
And there is some underlined language at the end of the paragraph. Would you read that language for me?
The locking arrangements not permitted on any door other than the main exit, and therefore the employees, security, and cleaning crews will have access to other exits without requiring use of a key.
Do you have any reason to believe that this language is not part of the Icc commentary?
No, I believe it's in the commentary.
So in fact, the ICC interprets the locking provisions of the code to say that a locking arrangement on an interior door is not allowed, and that employees, security, and cleaning crews have to have access to other exits without requiring the use of a key.
I'm trying to see what the rest of this section says, though.
Well, let me help you with that. So the code on page is produced on pages 2 and 3 of that memo. And it's section 1010.1.9.3, locks and latches. And I believe there is a section 2.2, which appears at the top of page 3, which refers to a readily visible, durable sign placed on an egress door stating this door to remain unlocked when this space is occupied. Is this the provision in the code that you're talking about that allows this type of signage on a main door?
Yes.
And then the commentary is produced, and it says the locking arrangement's not permitted on any door other than the main exit. Isn't that correct?
Correct.
And that's the ICC's interpretation.
That is. But it's not code either. It's advisory.
You disagree with the ICC then? You believe that it's allowed by the code?
No, I believe that the building official has the right to make an interpretation as to the application of a particular code provision, and the commentary is not code, but it is advisory. And also that's why the common solution to this is not this mechanism, but it's actually the interlocked door with the fire alarm system.
And it was your testimony that the code does not require 24/7 access be available to these various spaces, correct?
Correct.
Does the code expressly state that somewhere?
That it requires 24/7 access?
That it does not require 24/7 access?
I would ask the question, where does it specify that it requires 24/7 access?
Well, sir, where does it, I'm asking you the questions. Where does it specify that the doors only need to be, that there only needs to be access to 2 exits during normal business hours? Where does it state that?
The code says that access to exits need to be provided when the building is occupied.
So your interpretation is if people are in there, if anyone's in there, it needs to have 2 accesses, but if there's no one in there at the time, there's no need to have access.
If it's secured and no one is in the building, then yes.
Now, you spoke about the work area method and the choice of the applicant, but you also said that this didn't really matter here. Is that correct? Was that your testimony?
My testimony is that either way, the prescriptive method and the work area method both get you to the point that alterations must comply and that existing building components shall be allowed to remain.
Except when the building official determines that there is a safety issue, which you acknowledge the building official has authority to require changes then. So I'm going to ask you a question, Mr. Higgins, which I don't know whether you want to answer or not. Would you consider this arrangement to be safe for all of the tenants, patrons, cleaning crews, and everybody else who uses this building?
I wouldn't consider it to be unsafe.
Well, you consciously chose to turn my question around and say that it's not unsafe.
Well, I think
Why did you do that?
I think the code, I think building officials need to be very careful with determining the word safe. Even the application of the code, the architect and owner are responsible for compliance with minimum code, and building officials are responsible for enforcing substantial compliance with the code. But at the end of the day, there isn't a truly ultimately safe space. There's inherent risk in every space. So I think there are times it's very difficult to deem a building absolutely safe, any building that you're in. There are always risks associated with that building. So I would say that the code is intended to try to create as safe as possible spaces, but there are always going to be risks associated with any occupied space.
And your testimony is that the use of the locking door in the corridor does not make this building unsafe.
Not as proposed on the plans, though in my professional opinion, had it been proposed to me, I would have gone with the interlocked locking mechanism as the solution, because I think in that case, it actually creates a higher level of safety so that if there is a fire alarm condition in the building, that all of those doors would unlock and then anybody on that floor would have complete access to the space, to the exits.
I don't have any further questions for this witness.
Starting with the commentary again, does it say anywhere that there must be 2 exits provided? Or does it say, let me go back. The locking arrangement is not permitted on any door other than the main exit, and therefore the employees, security, and cleaning crews will have access to other exits without requiring the use of a key. If there's a cleaning crew in here, do they have access to an exit?
Yes, they do.
That exit, correct?
Correct.
And we assume that they have keys to this other spaces that they're trying to clean, correct?
That would be my assumption, yes.
Is it fair for, say, everybody in this room that anybody who came to this space either came up those stairs or came up that elevator?
Yes, or the other.
Or came up the back one and had access? Fair enough. In the email by Mr. Reifner, he used the words common lobby.
Correct.
I focus on the word common, which is common space. Is that the way you interpret it under the code?
Similar, yes.
And this is common space within this floor.
Correct.
So when Counselor goes on about you can't have a locked door except to a common, I don't want to mischaracterize his question, that you're not supposed to have a locked door to the common area. Is it fair to say that the code does permit you to have locked doors on floors?
I believe the code is silent on the allowance of locked doors on floors, though I think it's inherent right of a tenant to be able to have security for their tenant space.
Which is where I'm going.
Correct.
To your knowledge, does this door lock?
I believe it does.
Is this door any different than that door?
No, I don't believe it is.
To your knowledge, does the code require that this stairwell and this stairwell be connected?
No, it does not.
And I say connected as in,
Not inherently connected. It doesn't. There are provisions where a corridor connecting those would be required, such as if there was a third tenant on this floor and that third tenant could not gain access to that second exit, then I believe you would need to have a common corridor that provided access to both exits directly and connected them.
and that's, want to point out, if this was tenant space and that was a locking door,
Yes,
so this was tenant C, hypothetically,
correct.
this is a problem.
Yes, and that would be a case where if the applicant had come in with a permit to propose that to be independent tenant space C, then you would be, in fact, affecting the exiting plan of that third floor space and would, in fact, have code authority to require that those 2 stairways be connected by a common corridor.
Because this person would only have access via here unless you somehow made a door into here so they could exit out.
Correct, which wouldn't be allowed by code except in some small provisions about tenant spaces being 10% or less of the floor area of the tenant, such as in like a bank inside a grocery store or some other type of.
Because in that case, it's a tenant gaining access to the second space through another tenant.
Correct, and the code does prohibit that. And I believe that that's the intention of what the city is trying to prevent in this case. I just feel like it's not being appropriately applied.
That's right. So the crack addict comes up the stairs and is standing here and a fire breaks out. He doesn't have access to 2 stairwells, does he?
No.
Of course.
I mean, if those other tenant spaces are locked and they're just coming up to see if they're open or something,
That's right.
then no, they would have to turn around and go back down the exits they just came up.
And this tenant space was approved, to your knowledge, in 2018, correct?
Correct.
And let me repeat, that door is the same as that door.
And the scope of that permit was very similar to the scope of the permit that was denied, in that it was only a couple of non-bearing interior walls creating office or massage spaces, which is exactly what this current permit was also doing.
That's right. So the existing tenant A space only had these minor changes, but that door was permitted,
Correct. Or allowed to remain.
allowed to remain.
Yes.
Fair
As
enough.
an existing condition.
So here we are in the denied permit. Nothing has changed about this space,
Correct.
other than these interior partition walls.
Correct.
But there's nothing less safe about this space
Correct.
than existed in 2013 when it was permitted.
Correct.
And right there in early or middle 2018 when tenant A space was permitted.
Correct.
In your opinion, does it seem consistent that they would grant a permit to A, which has no additional requirements around their door? Because the same problem existed, correct? This is common area.
The same situation existed, correct?
Person comes up, is in here, I'll assume the massage therapy place is open on weekends. So on a weekend, when their person exits this door, and they are here in the hallway, they have the same problem as this tenant going out if this door locks behind them, correct?
Correct.
To your knowledge, is there any requirement that the door to tenant A be any different than this door to tenant B?
Not to my knowledge. No.
Mr. Higgins, you agree, do you not? Just to be clear, because I think counsel, as I understand it, may have stated something differently. You would agree, Mr. Higgins, that all spaces on the third story of a building like this must have access to two exits?
Yes, all normally occupied rooms and spaces shall have access to two exits. On the
And that would include these areas that you have referred to as the common areas, the lunchrooms, the bathrooms, and so forth. All of the spaces have to have access to two independent exits.
Yes.
And you mentioned in your testimony that building official approved this locking door in 2013, and your opinion was that because he analogized or interpreted the code to be that this could be something like the main door, correct?
I believe so, yes. Something similar to that situation, yeah.
Are you aware that the code allows the building official to revoke the permission of a locking mechanism even on the main door for good cause?
Yes.
And does that tie in with that provision in the international existing building code that we talked about the code, the building official having the authority to require changes if they deemed that the existing condition was unsafe?
Yes.
No further questions.
One question from me, or did you have further?
Nope, no.
My question, Mr. Higgins, was the interlock system you had described as a proposed solution. In your view, would that be applicable to both doors, the door to tenant A and the door to tenant B? Is that the idea?
I believe it is. I believe we included that as one of
I couldn't
the-
remember if you said it in that A6 or not. I was trying to understand what the difference between tenant A situation and tenant B situation was.
There were what, 5, 6, and 8?
Yeah, I believe
Letters?
includes-
A6 is
Yeah,
where-
A6.
Yeah, that's it.
And I couldn't recall if it talked about both doors or not, so.
I believe the solution that the applicant was trying to work out with the city, subject to this identification of this door needing to be not having a locking mechanism, was to propose this alternate solution that was in line with the 2015 Seattle Building Code, Section 1010.1.9.8. That does allow for the sensory release of electronic locked egress doors to resolve this situation. And in my professional opinion, I believe that would be an excellent solution to get at the situation where it would provide the safer situation that the city is looking for, and also provide security for the tenant spaces that seem to be the right of the owner
Sure,
of the tenants.
but you think it would be both doors, the door to tenant A and the door to tenant B?
I do, and I actually think that it would be also the doors on the backside to the other corridor. It would be all four of those doors.
Can you
So-
point to that for me?
I was just saying, you mean these doors?
The two doors that, go from the tenant space.
To this stairwell? Is that what you're?
And the same
Oh,
argument
okay.
the city is trying to make about somebody coming up and knocking on that door and being locked, still having access to only one exit. I mean, if for some reason there was a fire to break out right behind him,
So
and
the
they couldn't
crackhead
exit.
comes up, sets a fire in the bathroom, all of a sudden now, all the doors sort of open, and they can, if the fire has blocked that stairwell, they'll be able to run down through either A or B to get to that stairwell.
Right, because the doors would all unlock when the fire alarm goes off, and then this situation
Got it.
would not exist in any way.
Got it. Thank you. I don't know if that brought up other questions.
It did bring up a question for me.
Sorry.
If I can ask him, it did bring up a question for me.
Sure.
Fine with me.
You go ahead.
During the testimony that you just gave in response to the hearing examiner's questions, you mentioned the Seattle Building Code.
Correct.
Does the Seattle Building Code have specific provisions in it that allow for this interlocking fire alarm mechanism?
It does. It's Exhibit 6A6 in here, and it has the section right
Has
there.
the city of Issaquah adopted the Seattle Building Code?
No, it has not.
Is
But
there any provision in the Issaquah adoption of the building code which
specifically allows that?
specifically allows this?
No, there is not. But that is the common solution to this typical situation, which is why the Seattle, because they don't need to go through the state process to add amendments to the code, added it to their code so that it's very clear how to resolve this common situation.
But that's Seattle's code, that's not the Issaquah code.
Absolutely, yes. It would be an approved code alternate should that be the result.
No further questions.
Can I ask a question then? You're raised
I
by
have
this?
no issue, Mr. Haney, any issue
No.
there?
So is that proposed alternative allowed in other cities besides Seattle?
Many other cities do allow that as a approved code alternate, but they do it by a code alternate process because it's not specifically adopted in their jurisdictions.
That was
Is
it.
that it with this witness? And you had one more?
No, I had Mr. Moe on here just to testify, if necessary, to little facts like was the space occupied. I think it all was in the record at this point.
Okay, it's your case, so I'm not going to tell you how to proceed.
Okay, I'll leave it at that.
Okay, do we want to take a short break before the city puts its witnesses on?
I think we're willing to just go and get it done.
No, I need to break.
Okay, why
It's-
don't we take 5 minutes or
It's-
10 minutes?
It's 11:45. Honestly, I need to eat. I
Okay.
apologize. It's me.
Half hour? Is that long enough?
Yeah, I'm trying to think. Yeah. I'll run to Costco and get a hot dog or something.
Okay, yeah, because I'd rather push through because we started at 10 and we've only been here 2 hours. I was hoping we'd be out of here no later than 1. That's clearly probably not going to happen, but what if we take a half hour and try to be back at 12:15 and we'll dive right in?
Works for us.
Great, thanks.
Okay,